For every time there's a strike action, there's a real life consequences of this action. Nigeria has witnessed in the past few years lots and lots of strike. But the one that is raving right now is the 7 months prolonged strike of ASUU. What is the take of the law? What's the place of the judiciary in resolving such strike in Nigeria? Do they have a take? What's the place of the law? And why has this strike prolonged for such a long time? This is Seven Legal. Welcome. I am Olachi Anyekwara. And let's go on a commercial break. By the time we get back, we'll get onto the show. Welcome back from the break. This is Seven Legal, and as always, I am Olachi Anyekwara. Today, I'm talking about the prolonged 7-month strike of ASUU. We all know that a lot and lots of Nigerians youths are already at home, not going to school for the past 7 months. What is the place of the judiciary in resolving? Recently, we realized that ASUU was taken to court by the federal government. But we're here to discuss in today's show, what's the place of the judiciary in resolving such type of dispute? And with me to discuss this is Chika Nwago Esquire, partner Jackson Kabwe and Associates. Welcome, sir.
Thank you very much.
Okay, so I want to really understand this. Is strike the right way to resolve disputes in Nigeria, especially when it comes to the federal government and other institutions?
Okay, thank you very much. Well, I will start by saying that peculiar circumstances require peculiar actions. Over a while, since the beginning of our legal system, strike action, in consonance with other industrial actions, has been recognized as a medium which trade unions, workers, even employers can employ to press home and see the materialization of their needs and their demands, especially when it regards to terms of employment, conditions of service, and welfare of members. So yes, it has been recognized. Even the courts in an old case in Eche against State School Commission Board, the JCA then, or why is JCA as it then was, pronounced on the fact, and then he gave a deliberate and distinct pronunciation that yes, indeed, strike action is a legal industrial method for pressing home claims of trade.
Has it worked? Has it worked for the period of time you've used it to institute a decision or a complaint?
Well, in the context of Nigeria and our legal system, I would say for a fact that it has recorded at least 70% success rate over a period, because given the attitude and the impression of what is our federal government, strike action is the last means, the last hammer that these unions can actually use, wield, to press home their demands and claims. Because when strike actions are employed, it puts the whole system that is an issue at a halt. If it's, for example, ASUU right now, it has put the whole educational sector, especially for tertiary institutions, on hold until their demands are met. So it actually puts the government on a hot seat to see that their demands are met. So in my opinion, I strongly believe that for the context in which is Nigeria, strike actions are the most effective method of pressing on their demands.
Okay, concerning the recent prolonged 7-month strike of ASUU, which what's the place of the law? Because as an ordinary Nigerian, I would think the law should step in right now that the strike is prolonged. What's the place of the law, that's the judiciary, the constitution, concerning this strike that has affected our students for the past 7 months?
Okay, thank you very much. I will start by saying that basically the law that regulates any issue of trade dispute is actually the Trade Disputes Act and the Trade Union Act, Nigeria. Now, by the Trade Disputes Act, in terms of the judiciary, Section 2 of the Trade Disputes Act actually outs the right of action of a trade union to approach the court as regards a trade dispute. So it actually puts this right, this competence on the minister of labor, employment, and productivity for the purposes of interpretation of an arbitral agreement or collective agreement, or to ask the court to inquire whether in the circumstances of the case, the court should not intervene in terms of giving an injunction to restrain any further strike action or any contemplated industrial action, given the circumstances of the case. Now, by Section 1 of the NICN Act, which is the National Industrial Court Act, the National Industrial Court has exclusive jurisdiction to any matter relating to labor, trade unions, and any other related aspect in that field. Now, also by Section 7, now talking about intervention, it provides for the jurisdiction of the National Industrial Act as relates trade disputes and industrial actions, e.g. strike. Now, it puts within the powers of the courts to inquire and reach a determination as to whether, given the circumstances of the case, whether it will be in the interest of the populace, interest of the general populace, that the court should intervene and give an order, interim or interlocutory, as the case may be, for a seizure of industrial actions, pending the determination of the case, depending on what is brought before the court. However, it is still subject to the powers conferred on the court by the law. The law does not expressly confer powers on the court to enforce collective agreements.
Okay.
For example, the collective agreement that is the bone of contention of all this, the one that was reached in 2009, I don't think it is expressly provided by the law that the court, in the guise of intervention, can pronounce on whether the trade unions can validly enforce that agreement against the federal government or not. Because if you see, it is almost a case of an enforcer being asked to enforce against itself. The federal government ordinarily is the enforcer, and he also is supposed to be the subject of the enforcement.
So you're saying they are above the law when it comes to strike actions, that since they are the enforcer, there is no how the person suing or ASUU itself can be able to win such cases if it is presented in the court of law.
What I can say is that nobody is above the law. But however, the law is interpreted as regards what is provided for by the legislators. Now, the trade union is couched in such a way that it favors the federal government more than the trade unions, and as such that even the trade unions cannot on their own approach the court and seek enforcement of that 2009 agreement, which was collectively agreed by both parties. That is why I initially agreed and subscribed to that fact that strike action is the most legitimate and effective means of putting home or driving home their claims and making sure that the federal government obeys the agreement that was signed between ASUU and the federal government as regards the welfare of tertiary institutions.
So coming to the fact that what's it called, we are all looking for the welfare of the students, the federal government initially ordered the academic staff unit, that's ASUU, to court or sue them to court to call off the 7 prolonged time. What do you have to take on that? Do you think that's the right action to take in concerning this? And do you think the judiciary has the right, like you said, to order the ASUU, like they demanded, to close down or to cut off or shut off the strike actions that has been going on for some time?
Okay, thank you. With regards to the law, because I always make reference to the law when it has to do with interventions of the court, by Section 31 of our Trade Union Act, and also by Section 18 of the Trade Disputes Act, there are certain provisions and conditions that must be fulfilled first before an industrial action like strike can be legitimately embarked upon. And there are also conditions that should be fulfilled in the event that the strike action can be seized or at least declared illegal.
Okay.
Now, one of the provisions, Section 18 of the Trade Disputes Act, one of the conditions is in the event that the Honorable Minister of Labor, Employment and Productivity refers such trade disputes to the industrial court, it now becomes illegal for trade unions to continue
On the
strike.
So that means what?
It means that if they can validly employ that provision, then the strike will be declared illegal, and any member of the trade union, ASUU, that continues in the strike action will be running afoul of the law.
I think this actually exposes the discrepancies in our constitution, because if the federal government has such veto power to go to court and order and enforce that constitution, that means the institutions in Nigeria, don't have the right to actually go on strike, because the more they go, the federal government can institute such constitution and get it all out done. So I don't think. Do you think, that section of the constitution, or that veto power given to the government is quite good enough?
Well, at the end of the day, ordinarily the law is made for the citizens and not the citizens for the law. Now, the import of those provisions is for situations like this, where trade unions and their employers are at loggerheads and there's a deadlock. And it has protracted, especially in this particular circumstance. By that section 18 of the Trade Dispute Act, one of its first provisions says that there must be compliance to section 4 and section 6 of the Trade Dispute Act. And by section 4 of the Trade Dispute Act, when there is such a trade dispute involving a dispute of rights, there shall first, between the parties, explore settlement, amicable settlements amongst themselves. Now, in the event that they cannot settle, they are by law empowered within 7 days to employ a mediator to mediate within the parties. Also, for purposes of settlement. Now, in the event that they cannot settle, Section 6 empowers them to refer to the minister, to Honorable Minister. And then, if the Honorable Minister cannot still settle them, he can refer them to a conciliator under Section 8 of the Trade Dispute Act, or to the arbitrary panel under Section 9 of the Trade Dispute Act. Now, I am not sure whether any of these were done, but in any event, the law is that when the minister, under Section 17, refers these disputes, this hegemony, to the industrial courts, industrial actions like strike shall cease immediately. And that was why I think the Learned Council for ASUU, during the hearing on Monday, pleaded with the court that instead of outrightly giving an order of injunction, restraining further industrial action, that they should allow parties to still explore settlements.
Okay. Are there legal means of putting an end to the strike? Because I realize that in the process of their considerations and committee meetings, there are lawyers who were there probably to take down the cost of those meetings, and there are contracts that are binding based on their agreement. And I'm asking, one party should be in a breach of those agreements now. Can't the law itself order the party who is in the breach of that agreement, the demands of ASUU, can't they order them to take up and honor the terms of the agreement that was given? That's the final note. And second, just tell us legal means of putting an end to this ASUU strike and causing a change in our institutions in Nigeria, because what they are clamoring for is the right thing. There be a change in the structure in Nigeria, a change in the institutions, the physical nature of the schools in Nigeria. These things are the right demands, and I feel the judiciary should also understand that these things are right demands. I don't know way of legally putting an end and meeting ASUU at the point at least 50% down the line.
Okay, thank you very much. Let me restate what I said before. The courts are products of statutes. Now, it is these statutes that creates these courts that also give them the powers they can exercise, which means that outside what the statute provides for, the courts cannot go beyond that. Now, ASUU in 2009 reached a collective agreement via collective bargaining with the federal government for funds that should be for the welfare of the tertiary institutions in Nigeria. Now, ordinarily, by virtue of the doctrine of pacta sunt servanda,
Okay.
which envisages that the terms of a contract should be sacrosanct. In fact, the terms of a contract should be obeyed. We shouldn't have gone to the extent of letting ASUU denigrate into industrial action or strike, because that is the only weapon they can wield against the federal government. Because as I said earlier, Section 2 of the Trade Disputes Act totally divests any trade union the right to approach the court in regards of any trade dispute. Ordinarily, they would have approached the court and said, okay, there's an agreement existing. The current government is not denying the existence of that agreement, at least from what I heard from the Minister of Labour. What they're saying is that the agreement, given the prevalent economic circumstance, can no longer be enforceable.
Okay.
So they're not saying that the agreement is not existing. They're not saying that the agreement is not valid. But they are saying that they want it modified. To what extent ASUU wants them to meet them halfway, 50%, 30%, as the case may be, that is left for those that are in those meetings. However, the court is not empowered to enforce such agreements, especially against the federal government, given the provisions of the Trade Disputes Act and the NICN Act.
Okay, sir. Okay. What can you say about the current state of schools in Nigeria, and what do you think the federal government can do to be able to increase the quality of education that we're having in Nigeria?
Let me refer back to what our president, in his speech recently in the UN summit, he mentioned that education is the bedrock for development and economic growth of any nation. So if that is in truth what the condition and situation ought to be, then I believe that they should at least confer priority to our education sector. None of our tertiary institutions, at least public, in my own opinion and understanding, can compete with its contemporaries outside the nation, even outside West Africa. So the dilapidated state and the denigrated status of our tertiary institutions tells on the people and the kind of products that these institutions will give out to the society, and which will also denigrate and pull down development goals in this country. So my candid opinion and advice on this is education should be made a priority. This is in view of the fact that whenever it is an election year, the attention shifts, the focus shifts onto election, and every other aspect of the economy is rendered secondary. Education, unfortunately, is also a victim of this prevailing situation.
Okay, thank you very, very much, Mr. Chika Nwago. Super excited to have ended the show on this note. Research have shown that in the next few years, there will be a lot of gap in our educational labor sector. I hope the government, which is coming up in 2023, looks into the educational sector and improves the state of education in Nigeria. We also hope that in the next few weeks, the ASUU strike will come to an end. Our students will go back to school. This is 7 Legal, and I'm Olachi Anyekwa. I'll see you next week.